It's nice that when we get geeky about certain things on the Four Boxes Diner long ago, we often see them bearing fruit today, meaning things we talked about a long time ago become reality as time passes. That is very good news when it comes to a critical thing that we've talked about in the past, the importance of being disarmed only if you are found by a court to be a violent danger. That thesis, that theory is becoming more and more the case all across this great land, including now by the United States Department of Justice, courts and beyond. Let's explain all this when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America at the 2025 Gundies Awards out there in Las Vegas. Thank you all for your support. I truly appreciate it. I hope to continue to work hard to bring you great content in the year of our Lord 2025. Okay, folks, so here's some good news. This is very good news for the Second Amendment. I'm happy to report also that it's the kind of thing that you've heard about before repeatedly on this channel, the Four Boxes Diner, which is important because I try to tell you where I think the hockey puck or the ball is going to move, where the policies are going to go to, and I'm happy to report we seem to be predicting correctly yet again. What do I mean by that? One of the things that I've talked about for the last several years on this channel is the importance that Americans can only be disarmed if they are found to be a violent danger to themselves or to others. Not some airy-fairy definition of a felony as defined by some legislator somewhere that says if you have the wrong piece of hardware in your closet, now you're some crazy felon and have to go to prison for years. And beyond that, you are permanently disarmed and lose your Second Amendment rights. No. This is good news because what we're starting to see is a coalescence, if you will, of this thesis that I've been hammering home in law review articles, on TV, on radio, on this channel and beyond, and speeches to various gun rights groups. The importance of making sure we win a critical strategic battle, again, that no one in America can be disarmed and deny their Second Amendment rights unless and until they are found after due process to be a violent danger to themselves or to somebody else. That was essentially the central thesis of the U.S. Supreme Court's decision in the United States versus Rahimi. So even though Mr. Rahimi lost that case in 2024, meaning his Supreme Court appeal lost, if you will, his fight over that appeal lost, the fact is the Supreme Court's rationale in finding that Mr. Rahimi could be disarmed temporarily, under federal gun control law 18 U.S.C. 922G, was because he admitted to be and was found to be a violent danger to others, to his girlfriend, because he engaged in 5 different shootings or so. He also took his girlfriend's head and hit it against the dashboard of the car and then shot at witnesses who saw it. This was not disputed. He admitted to all of this and acknowledged that he was a danger to others, including his girlfriend. So there was no dispute about this. And the Supreme Court said that if you're found to be disarmed, or I should say if you're found to be a danger to others, you can be disarmed temporarily, consistent with the Second Amendment. And they talked about the historical analog laws at the time of the founding that justified this conclusion. Now, the reason why you need to understand that backdrop is what has just occurred from the United States Department of Justice is a huge, huge deal. In fact, there's 2 things going on here that are huge deals out of this United States Department of Justice. Very good news for the Second Amendment. The first big deal ties into this discussion of violent dangerousness, and that is a public policy statement, a formal statement issued by Attorney General Pam Bondi's office, by her Chief of Staff, Chad Mizell. This specifically says that going forward, the U.S. Department of Justice, in their decisions about how they're going to approach the enforcement of American federal criminal law, is that they're going to laser focus on those people who are, ready folks, dangerous, 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 and not to others, which speaks to something we've talked a lot about in this channel, the difference between malum in se crimes, which means evil in and of themselves, murder, rape, robbery, and the like, versus malum prohibitum crimes, which are crimes only because a bunch of legislators got together and labeled it a crime. The classic example in my mind is the length of a gun barrel. If it's too short, it's a short barrel rifle or short barrel shotgun and you go to prison, and if it's too long, it's perfectly fine. There's nothing intuitive or moral or evil or good or bad or anything about that. It's an arbitrary line drawn by legislators. No connection to morality, no common sense associated with it. It's literally just a made up line. Now, the reason why this is important is because of the statement from the U.S. Department of Justice, which says that moving forward, they're going to laser focus on dangerous individuals. And the reason why this statement was made by Mr. Mazzell, an attorney that works as the chief of staff for Pam Bondi, Attorney General, is because it really tells us where their head is at. And where their head is at is very good for the Second Amendment. Here's what he wrote in his response to comments made by various people about the relationship between the Department of Justice and Eric Adams, the mayor of New York City, and the fact that they're no longer going to pursue, at least for the moment, criminal charges against Eric Adams. Here's what the Department of Justice had to say through their spokesperson, the Chief of Staff for Pam Bondi, Chad Mizell. The decision to dismiss the indictment of Eric Adams is yet another indication that this Department of Justice, under Donald Trump, of course, will return to its core function. Listen carefully, folks. Will return to its core function of prosecuting dangerous criminals, not pursuing politically motivated witch hunts. The fact that those who indicted and prosecuted the case refused to follow a direct command is further proof of the disordered and ulterior motives of the prosecutors. Such individuals have no place at Donald Trump's or any, really, Department of Justice. Powerful language. And that language about prosecuting dangerous criminals is not a trifling. It is major, major, major big deal. Because as you know, virtually all, if not all, federal gun control laws are malum prohibitum crimes. They're victimless crimes. They have no connection to morality in any respect. They're just arbitrarily drawn lines about hardware or something like that. They have very little connection, if any, to morality or anything associated with it. And the fact is, this Department of Justice is indicating that they want to focus on dangerous criminals is very good. Because first of all, they're drawing a distinction between criminals as defined by federal law and dangerous criminals. It's the dangerous criminals that we worry about when we go out to our cars, when we walk through parking garages, when we walk down the street, when we have dinner at a restaurant, right? We're not worried about some, yokel who has screwed up the length of his barrel or done something else with, some solvent trap or some other nonsense like that. That's like, okay, whatever. Okay. We're worried about dangerous people doing dangerous things to Americans. That is the focus. And the fact that the Department of Justice just said that in the context of the Eric Adams case, again, Eric Adams, whatever you want to say about the guy, there's no violence associated with Eric Adams. Whether he's a good or bad guy, I don't have a view. Whether he violates some technical law or not, I don't have a view, and I don't care. He's clearly not a violent danger, and that's the key, because that is where we should be focusing our attention. And by the way, if you support the right to keep and bear arms, you too want robust enforcement against violent criminals, because it's the same violent nut jobs who are the same people that will go out and shoot up a school or shoot up a store or engage in some sort of violent crime and kill people with a gun or whatever, that encourage calls for more gun control and encourage calls for more restrictions on our right to keep and bear arms. So when we're dealing with violent thugs and nut jobs and psychopaths, we do want the law enforced vigorously against them and get them locked up either in a prison or perhaps locked up in a mental institution so they're off our streets and cannot hurt innocent people with guns or otherwise. And if they hurt people with guns, as you know, it increases costs for gun control. So we in the Second Amendment community should want violent thugs and dangerous criminals to be off the streets for a whole host of reasons, including protecting our Second Amendment rights. Now, that's not the only good news coming out of the Department of Justice involving our Second Amendment rights. And some of this may not be obvious to you, but it's things we've talked about. And when I explain it to you, you will remember prior videos and realize, we got it, guys. We're on the right path. We're making great progress. Remember how I explained to you in many videos the importance of institutional reform litigation and how we need to take the notion of institutional reform litigation, which is when civil rights lawyers or the United States Department of Justice's Office of Civil Rights brings lawsuits and legal challenges against, let's say, local police departments or states over either voting rights or undue and improper behavior by law enforcement agencies like police departments and so on, and uses that to force changes, institutional reform litigation, to force changes. Sometimes we see institutional reform litigation historically against segregated schools to force them, for example, to become desegregated. Sometimes we see it against prisons that constantly violate the rights of prisoners. You'll see institutional reform litigation against prisoners to have those prisons reformed. And the way a lot of this works is the judges appoint monitors to oversee the police departments or the prisons or the school districts, whatever it is, to try to get them lined up with American civil rights. And one of the things I've talked about on this channel, which you're familiar with, is we should, through the U.S. Department of Justice Office of Civil Rights, hopefully that will be run by Harmeet Dillon, an attorney from California, who I knew back in her days in New York City, but that's a separate story. The Harmeet Dillon is excellent, and if she takes over, and she should, she's been nominated, let's just hope she gets confirmed, the Office of Civil Rights for Donald Trump's Department of Justice and Pam Bondi, we want her to laser focus on, among other things, licensing divisions in like NYPD, New York State, California police, wherever they issue concealed carry licenses and they delay it, either make it super expensive to get that license or delay the process to actually get your license. We want the Office of Civil Rights to crack down and to bring lawsuits or otherwise challenge them with a form of institutional reform litigation to get the stuff turned around. The reason why I remind you of that background is there's already good news, because the same Chad Mizell that I made a reference to in the early part of this video is now on the record saying that they're trying to thwart Biden's attempts at institutional reform litigation involving police departments, which tells us that on the Department of Justice's mind and Pam Bondi's mind is almost certainly looking to use the Office of Civil Rights in some favorable way to advance American interest and not just harass cops for the sake of harassing cops. Here is what the Department of Justice had to say about this kind of institutional reform litigation that Joe Biden was performing. And I think it's great that this is on their mind, because this could be a sign of things to come in a way that's quite favorable to us. Here's what the Department of Justice had to say just recently about Biden's attempts to change these law enforcement agencies, something that we may ultimately be able to do when it comes to concealed carry licenses. This is what it says. The Trump administration is putting a halt to agreements that require reforms of police departments where the Justice Department found a pattern of misconduct, according to a memo issued Wednesday. The new administration may wish to reconsider settlements and consent decrees negotiated and approved by the prior administration, said the memo issued by Acting Associate Attorney General Chad Mizell. Mizell ordered the Justice Department's Civil Rights Division to not execute or finalize any settlements or consent decrees approved prior to January 20th, 2025. The memo also orders civil rights lawyers to notify Mizell of any settlements or consent decrees finalized in the past 90 days. According to this memo from the Trump Justice Department, the memo furthers the department's goal to speak with one voice in pursuing the administration's priorities. This is excellent news, because what it means is this: two things. One is those absurd crackdowns on police departments that are simply being harassed by the Biden administration and previously by the Obama administration for doing nothing but actually enforcing the law against people that were misbehaving, number one is that nonsense going to go away. But relatedly, though, it's clearly a sign that the Trump Department of Justice officials at the top are very much aware of this type of institutional reform litigation, because if they weren't aware of it and weren't focused on it, they would not have issued a memo just a week or so ago telling these civil rights lawyers and these Justice Department lawyers to stand down with what you're doing. We're going to reassess this, and maybe we're going to make some changes. And I'm optimistic that a possible change that we may see could be arguing in favor of what we've talked about many times before on this channel, the importance of trying to crack down on these licensing divisions that take too long to issue a concealed carry license and or make it super expensive to get one. Because as you know, you cannot impose, well, two things. One is you can't impose a targeted tax on constitutional rights. We know that from Minneapolis Star in the 1980 Supreme Court case. We know that Harper versus Board of Elections, the case from the 1960s, a $1.50 poll tax was unconstitutional. So again, to the extent you want to argue, and I think it's a valid argument, that dragging your feet to issue a concealed carry license in a shall issue permitting regime or making it super expensive violates the Minneapolis Star case precedent, as well as Harper versus Board of Elections. And of course, beyond that, we know that the U.S. Supreme Court in the Bruin case specifically said, although they're sort of tacitly for now, impliedly for now, suggesting that shall issue permitting regimes may be okay, consistent with the Second Amendment. But one thing was absolutely not okay would be any kind of licensing regime that abuses the amount it costs. I mean, it costs so much money that it becomes abusive, or it takes so long to get your license it becomes abusive. Neither of those are allowed. Those are clearly verboten, not just under the Minneapolis Star and Harper precedents, but also under the clear language of Nyserpa versus Bruin, the Supreme Court decision involving the Second Amendment in the year of Lord 2022. Of course, you know that. So anyway, this is some very positive developments. I think it's a huge deal that the Department of Justice is going to laser focus on dangerous individuals, because I think a lot of people, they get crossways with the ATF, they get crossways over federal gun control laws. They're not dangerous, and they're, these are victimless crimes, malum prohibitum crimes, and I think it's great that DOJ is going to focus their attention on dangerous people. I think it may also be consistent with what we've talked about recently, that the ATF's law enforcement officials, the law enforcement agents, not the licensing people, not the inspectors, but the law enforcement folks with the power to arrest, are being redeployed away from gun-related activities and pushing them into immigration enforcement, because it's pretty clear the Trump administration views illegal aliens to be dangerous individuals in this country, as opposed to American gun owners who may cross some ridiculous arbitrary line drawn in the sand by a bunch of legislators that don't know a suppressor from a trigger from a barrel shroud. So anyway, folks, I think this is all very good news. Again, we will continue to report on activities of this Department of Justice, but so far so good as far as I'm concerned. I think we'll have a lot more information about where this DOJ is going to be going over the next couple months, but I'm cautiously optimistic. We're certainly going to be 1,000 times better than we were under Joe Biden, or we would have been under Kamala Harris. I think we're going to be doing even much, much better than just stopping bad stuff. I think there's going to be some good stuff coming down the pike. But again, as I've said before, the history of the future has yet to be written, so only time will tell. But in the meantime, thank you for tuning in. I appreciate your time here at the Four Boxes Diner. Make sure you follow me at Four Boxes Diner on X, and don't forget to subscribe both to Rumble and YouTube. We're trying hard to get to 200,000 subscribers on YouTube here at the Four Boxes Diner. And again, thank you for your time. And I look forward to seeing all of you again very, very soon here at the Four Boxes Diner.
Orders up. Table 2A.